Part 9, When a Woman Stalks a Man, Legal System, Mental Illness, Spirit Children, and Hoodoo. So, we have an arraignment in November. She's arraigned on criminal contempt charges, and these charges can give you a sentence of up to 180 days of incarceration. Now, she's arraigned in November. At the court date, they assign her a public defender. She requests for an African-American public defender. So they pushed the next hearing back a couple of weeks, giving themselves enough time to find her an African-American public defender. So a couple of weeks pass, there's a hearing, they found her an African-American public defender. Then he states that he needs some time to, deal with the case or, to build his defense. So they pushed the case back a few more weeks. So we were supposed to go to trial. Initially, we were supposed to go to trial in December. Now it's pushed back first to January. Now it's pushed back to March 23rd. So we're supposed to be having this trial on March 23rd. Right before the trial, she requests that public defender is dismissed. She approaches the judge and the lawyer approaches the judge and so forth. She says, he's not defending me the way I want him to defend me, so therefore I want to represent myself. So this is at the March 23rd court date, and therefore they say, okay, well, you can represent yourself. This public defender will sit with you in an advisory capacity. And now the trial is pushed from March 23rd all the way to June 20th. So once again, on the administrative side, when you're going through this and you're navigating your way through the court system, sometimes there are continuances, sometimes there are delays, and sometimes these things are manufactured. As we said before, she's very litigious. When we get into the civil suit, you'll see that she's filed 1,000+ pages of foolishness as part of that civil suit. She's just sitting down, writing nonsense and constantly filing over 40+ motions in the civil suit and so forth. But she's also filing against the United States government in Kansas and Wyandotte County and all these other different things. And she's moving around. She knows her way around the courtroom to a certain extent with regard to these procedural maneuvers. So instead of us going to trial in December, she says, hey, I want an African-American attorney. She even goes on her Facebook page and says, hey, if you want to request a different kind of attorney, you can do that. Don't let these people talk to you and tell you what you can and cannot do. That was a way for her to push the date back. Once she gets the African-American attorney, he needs time to, check out the case. Once he has time to build his defense, then right before the trial, she says, I'm not going to use him. I want to fire him. I need time now to, defend myself and build my case. They can see that she's mentally ill. They can see that there's a problem. The public defender can see that, but it is her right to defend herself. Pro se is not against the law. They did make sure that the public defender sat in an advisory capacity, but she's able to represent herself. But because of that, she needs more time. They didn't give her just 2 weeks. They gave her almost 3 months. So now the trial doesn't happen until June 20th. Through her manipulation, she knew she was going to fire the African-American attorney as soon as she asked for one. She knew in December when she said, hey, I want an African-American attorney. She knew that she was going to ask to, represent herself then. She just knew it was going to push the time frame back, the clock back. Her goal was to try to get the civil case done before the criminal case, thinking if she won the civil case or got some form of concession from that, she can utilize that to, impact the criminal case and try to pretend like she's, innocent. The problem is she wasn't able to serve me with a summons for the civil case. So there was a hearing on at some point in January. She wasn't able to serve me. She wasn't able to serve me the summons for the civil case until June 20th, the day of the criminal contempt trial. And when I was sitting in the hallway outside the courthouse, sitting with the Assistant Attorney General who was prosecuting her, she came over and gave the summons to the Assistant Attorney General, who then handed it to me, which was fine. I didn't mind at all, because I knew she was going to be convicted that day, and she was going to have a criminal conviction of violating an anti-stalking order. So when I responded to the civil case, when she said I defamed her because I called her a stalker, now I was going to have a court order saying that she is a stalker. Not only the original anti-stalking order from the civil side, but now a criminal court order. So we go into court. It's June 20th. We go into court. And of course, she's pro se. She's representing herself. She's her own lawyer. So that means that she has to cross-examine me. So I'm on the stand. She's operating as her own lawyer, and she's asking me pointed and silly questions, trying to put forward a foolish defense, a necessity defense. Now, there is a process whereby you can put forward the necessity defense to override violating an anti-stalking order. If you're not supposed to be within 100 yards of somebody, and if, the car caught on fire and you ran to save somebody and you got close to the person, that's a necessity defense. And you can't be convicted criminally if it's something like that. She tried to raise the necessity defense in this case. And this goes back to that first notice within her little fake book about, oh, by the way, I didn't tell anybody that I've been enslaved for 40 years since birth. I didn't tell anybody that because, I was sending coded messages and I didn't want my children to be sold into slavery, but eventually they were. And since they were, now I have to tell the full story. And I wrote a book about it and about the black township and all this other nonsense. She's weaving this story to get out of this criminal conviction. If she can say that the only reason I came to his house originally is because I was trying to escape slavery and my children were in slavery. And you're going to see all throughout the civil case, those 1,000+ pages of information, her talking about she was in slavery. But later on in the case, she'll talk about how she was working with the city, and when we said she was mentally ill and, all these different things, she took offense to that. Well, if I'm mentally ill, how am I working with the city? And I've got awards from alderpersons and so forth for my great work and volunteer work with the city. She forgets that she was telling people that she was in slavery for 40 years. I mean, if you're working with the city and you get an award for your volunteer service and there's a ceremony and the alderman or alderwoman gives you an award for your great service in the community and all the things you've done, you couldn't have whispered to the alderperson, yo, I'm in slavery right now. So, but she's building this narrative to get out of this criminal case. If I can say that it was a necessity because I was escaping slavery and I sought refuge in his home because he's a spiritual leader and he's obligated to assist those who are part of this ancestral religious community, and he's assisted other people before. So therefore, she explains she had an expectation, a reasonable expectation, that if she escaped to seek refuge with her children at my home, then I would assist her because we've assisted other individuals who had, issues. And we have created fundraisers for people within our community who went through some kind of tragic, circumstance, and we raised $1,000, $1,600 and so forth to assist, certain families. She's never been part of our community. She tried to parasitically attach herself to our community and myself in general, but she's never been a part of that. Recall, the first time I met her, it was a 1.5 minute conversation, just like I talked to everybody else. 1 year later, she came to some workshops. She sat in the audience like everybody else. We had no interaction. 6 months after that, or actually 7 months after that, she was at my house with her 3 kids. After telling me she loved me and ached to be near me and knew that I was the one even before she saw me. When she first saw the website, before she saw me on the website, she knew I was the one, and she felt like we were married already. So she's putting forth this necessity defense. She's asking me, aren't you an Odwirafo? What is your role as an Odwirafo? Are you a priest? Are you a therapist? Do you do divination for people? Aren't you obligated to assist those who are in need, who are part of the community? And of course, I share with, the court, this individual is not part of my community. I've been telling her for the past 3 years. In fact, at that point, this was actually last year, so I've been telling her for the past 5 years. At that point, it was 4.5 years to never contact me for any reason, under any circumstances. I showed them the information about the cyber stalking for 3 years, and then her showing up again and so forth. So one of the most damning pieces of evidence was the August 28th email. The same email where she said that I was assigned her as my divine complement, and she felt like we were already married and so forth. So here you have this judge, as well as the assistant attorney general, reading the email and trying to pronounce Inyamewa and Inyame and Nsamanfo and Odwirafo and Odwirafo and Abosom, and it was just nonsense. But at the end of the day, when they read the email, when the judge reads the email and she's talking about, I love you and I cherish you and I want to be with you and we're already married and so forth. And 4 weeks later, she's at my house with her children, unannounced. That's all she really needed to see. So she was found guilty. She was sentenced to 180 days of incarceration. However, it was suspended contingent upon her completing 1 year of probation. She had to undergo a psychiatric evaluation. She also had other probationary requirements and so forth. And that was the verdict. So now she's on probation. We leave the courtroom. 1 week later, she violates the court order.